morning, John. Hi, this is Anthony, parent of IRS Medic, and I have John Richardson and Keith Redmond with me. And today we're going to be going over a court decision that came out with Charles Moore, Kathleen Moore versus United States of America. This decision just came out by Judge Conaher. They're French spelling, I guess. And basically what happened in this case is there's the transition tax that was part of the Tax Cuts Jobs Act of 2017. And many people have commented that it's really not an income tax. It's more of a property confiscation because you are changing the definition of what income is. In this case, the petitioners brought a case against the government looking for their money back for transition tax they paid. The court, not really a surprise, denied the request. And with me is John Richardson, and both of us have gone over this. And fundamentally, I think it comes down to the judge just didn't understand really what's going on. This opinion's littered with sort of half realizations, not quite going the entire point. And really, here's sort of the issue that you have is that you're having judges who might have a pretty good understanding of the law not understand what's really going on. So they could get into the wrong decision, sort of the wrong way pretty easily. The income tax is so complicated, judges usually don't like to decide on it because it is so complicated. And so we end up, and also people don't want to talk about it. People don't want to sound like they sound stupid, which is kind of funny because I'll show you here why you can never sound stupid if you're a federal judge and you're writing stuff like this. Well, yeah, we got some problems. Anyway, John, so here it is that the petitioners lost. And why don't you give me, what are the things that we should be looking for in this opinion? What stood out to you?
Well, what stood out to me first and foremost was that there was nothing in the decision that, really explained why the transition tax is so unfair to individual owners of CFCs and particularly Americans abroad. So that stood out. But secondly, what was fascinating about this is that the judge had no problem absolutely describing and finding that the transition tax is a retroactive tax. But even though it was a retroactive tax, he basically said, well, it's perfectly legal, it's perfectly constitutional, and we really don't care. Now, it's kind of like we talked about Glenn Shaw Glass in a previous podcast, and one of the points we made is that nobody could have foreseen how far that decision would go at the time that it was rendered. Well, in this case, what the judge is really saying is, hey, no problem. Absolutely, this is retroactive, but so what? It's completely constitutional. Now here, this may apply to a small number of people, but I mean, what's to stop somebody from using this decision as a precedent and just going back and imposing retroactive taxation in circumstances where it appears to be less likely? For example, as you know, there's a $250,000 sort of threshold before somebody pays capital gains on a house. What's to stop them now from simply going back and saying, oops, sorry, now you're going to have to refile, including that $250,000 as income?
Well, actually, I would stop you there because there's a retroactive, there's the retroactive part. Okay, we can agree to that, but I don't necessarily see the income part. And that's sort of the problem that I have with this. That the first thing that we do with the transition tax is you learn this new term. Well, what's this new term? Well, you're taxed on your earnings and profits. Like, okay, well, why is that? Why am I not taxed on your income? Well, because. And that's sort of where it kind of goes off the line. Like, why do you want my past earnings and profits? And this is, I think, the point that you're getting to in the due process. And this is why it's absolutely horrible what happened. I mean, this is pretty glib, what occurred here. And
well, Anthony, here, let me just outline, and you can agree or disagree. Here's what I think actually happened here. First of all, this transition tax is imposed on an individual shareholder on income that he never received.
Exactly.
Second, the basis for imposing the tax is the individual is a shareholder in a small business corporation. The corporation has no obligation to distribute the income to the shareholder. The tax itself was based on the retained earnings of the corporation, and those earnings belong to the corporation and not to the shareholder. Third, these retained earnings that were subject to tax, it's not current income, and this is a point you're making. Yeah. It's past income, which was earned during the period from 86 to 2017. And at the time that this income was earned, from 86 to 2017, the law specifically did not require that this income be attributed to the individual shareholder. So, when people talk, the way I would put it is, in other words, this is taxation based on fake income,
Yep.
fake income that was not even earned by the individual,
Right.
was earned by the corporation. And to add insult to injury, the income was earned in past years, making this, and this is what the judge confirms, making it absolutely a retroactive tax. I mean, you can't make this stuff up.
Right. And there's the judge saying, "Oh, it doesn't violate due process." After all of that, it's not one thing. It doesn't satisfy Glenshaw Glass. If Glenshaw Glass stands for the touchstone of all income tax cases, it certainly doesn't meet it. Glenshaw Glass has a realization requirement. Some dude on a piece of paper in Spain said I made $1 million doesn't mean I have $1 million. But that's basically what the taxes say, what the code is saying. If somebody says here, and what you said about the corporation, that's corporate profits. You're acting, the code is acting as if, well, every foreign corporation is basically an alter ego, a private piggy bank of every US person. That's basically how it's acting. No, those corporate formalities have to be met, and there's other shareholders. And they might not be so hip with their property getting confiscated for you to pay a tax bill that's not a bill on your income, just the government stealing what was earned by the corporation. And this is so I think this is and here's really the issue. And I think that this, when you analyze this, it becomes very clear this is just complete theft. That the judge just basically says, well, we've allowed the government to steal so much in the past. Who are we to say they were wrong before? So we'll just sort of let it continue. That's basically what you get on his whole analysis of other things. Like, yeah, well, they've been doing this kind of the way it is, and so looks like the way it is.
Well, it's another example of a very disturbing trend where the U.S. tax code is inventing income where it doesn't exist, particularly in relation to Americans abroad, and then basically taxing it. It's as though they're saying, these Americans abroad, they pay so much tax outside the United States that, they don't pay enough to the United States. So I think what we better do is let's invent some fake income that's definitely not income in the other country. Just give it to them,
yes,
and make them pay tax on it.
This is not income in the other country. No one says this is, and I guess, even the IRS, no one at the IRS is claiming this is an income tax, because they claim it's a tax on earnings and profits, which is, guess what? Not an income tax. So we have and this is my point to everybody out there. When you're feeling stupid that you don't understand the income tax, just understand we have a federal judge who just said a tax not on income is totally fine. Totally fine. A seizure on your property, right? Your past income, we would say we count that as property. A seizure of your property because we changed something in the law, and because, well, we don't know why, but the answer is subpart F. And I think that's what it comes down to, John. You kind of see that too. It's the circular logic that we see. Well, what's the reason why? Could you try to walk us through this is hard. Try to walk us through the government's logic on why this is income.
Oh,
that's easy. Okay.
It's income because we're going to call it income.
Okay.
And the reason we call it income is because subpart F of the Internal Revenue Code defines it as income. In other words, what it absolutely does not do is look at, what the traditional definition of income is. Okay. Now, one could argue that, well, with what we've understood subpart F to be up until now, at least there was income somewhere, right? Income earned by the foreign corporation. Right. There at least was income, and that income was attributed. In this particular case, there's no income at all. The corporation didn't earn it. It had been earned it had been earned in the past and was not subject to U.S. taxation. So at that point, it was just capital. I mean, it's certainly not a tax on current income. So I think what they did was, I think their view is that by simply using the subpart F mechanism to create the taxation, they're saying, well, because it's in subpart F, it must be income. That's what I think the judge is actually
There
doing.
you go. Right. Subpart F is that magic wand. You don't need to do any more. Just say the word Subpart F. Your analysis is complete. That's it.
In
You're
other
done.
words,
Because
it's
that's a
like
really complicated thing. We're not going to get it. You know, basically, the
just
judge is saying,
create
look,
income.
yeah, well, the judge is like, Subpart F is really complicated and I don't really understand it. So I'm just not going to analyze it, basically.
Subpart F for listeners is it's horribly detailed, but the concept is very simple. It's where what they do is they take the income earned by a corporation, which is a separate legal entity, and make an individual pay tax on the income earned by the corporation. That's what it is.
Yeah.
Hmm.
Now I think
So-
now one thing here in the opinion, and Keith, this is my question for you here. In the
Yeah.
opinion, we're talking about the look back period. Like, well, how many years of this do we have to do? And I'm looking, they're like, wait, and here's it says that 30 years is not onerous. Here it is. The court says
Yeah.
30 years isn't so bad. And so my question is, Keith, how would someone know you had this 30-year buildup of E&P? How would the IRS
That's
know
true.
about it?
Well, that's a good question. Well, certainly, if you're an American overseas with a small to medium-sized business and have not been in the U.S. tax system, it's almost an impossibility for them to know about it at all. So, in my layman's opinion, there's no incentive there for them to even enter the U.S. tax system because of this, because they would lose their shirt. Now, for someone who is in, American overseas with a small to medium-sized business who's in the U.S. tax system, that's a good question. I don't know. I don't know.
I'll give you an answer. If they've been filing the form 5471 properly, it's Schedule J. There's a line that says what the basically what the retained earnings is.
Schedule, but here's my point: is who fills out Schedule J?
A person is required to file form 5471.
Right. So the only way my point is this: the only way the government knows anything about this is because you've been in compliance.
Yes, no doubt about it.
So what we're seeing here is a compliance tax. This is a tax on people who have been in compliance, because if you weren't in compliance, they would never know. They would never, there's no way for them to ever know. And as we've discussed before, the audit rate of these international returns is incredibly low. There are many reasons why. One of the reasons being they're too complicated for the IRS to do. About half the auditors won't touch them. That's the truth. Half of field auditors won't touch an international audit. And then you could see that in the own IRS's, the TIGTA has a report. The Treasury Inspector General has a report out recently that shows there's so few audits. It's ridiculous. And so this is the point that I think the government needs to be very careful of, that we are really entering to a point where people are going to start to feel like chumps if they haven't already. If you comply with the code, you will be punished. And if you don't, right. I mean, well, here's the thing here, because, remember all of these crackdowns look, I could tell you every crackdown the IRS was promising about people with unfiled FBARs, about people who made quiet disclosures, about the vast net of arrests that were going to happen and shut people down. And guess what? It never happened. It was all an empty threat. The IRS never did it. And that's great. You scared people into compliance, but guess what? People are also watching. For the past 10 years, you guys have just been, the only reason you've assessed penalties is because of people's own compliance. That's the only reason. They pat them. Look at their press releases. They pat themselves on the back. Look at this. We got $10 million in penalties and fines. It's like those were people who were voluntarily complying with you because you scared the crap out of them. Okay. Guess what now? Guess what? Those people are now feeling like, I'm not so sure if I did the right thing. And the people who have not done the so-called right thing, how do you think they're feeling right now?
They're breathing a sigh of relief.
Yeah.
So what does an American?
This is why compliance is the first step towards renunciation.
Yeah.
Which,
I guess you kind of answered my question. So what does the American overseas with a business who's been compliant, what are their options with this situation? Renounce?
Well, a renunciation won't undo the tax that was imposed
on
you.
I think that I think that they've got to renounce. All right. Because here's why. What we're seeing is example after example where the U.S. All right. So first of all, the U.S. is clearly moving towards a system of taxation that is dependent less and less on realization events, right? In other words, these fake income, types of things. Number one. Number two, they do not take into consideration the problems of Americans abroad, that is, people who are subject to a separate tax system. Basically, I think they've got to get out. I really do. Years ago, I thought, well, it's going to get better, but it's gotten progressively worse. And it's not so much what this decision is that's the problem. It's that when you look at the due process analysis, there's absolutely no consideration to how this affects individuals generally and how it affects Americans abroad specifically. It's as though, you may remember, Anthony, in law school, a constitutional case called Carolyn Products. And the famous Carolyn Products footnote in the equal protection context was talking about groups that are politically powerless. And that's where Americans abroad are. And so even those who are not directly affected by this decision should understand that they just dodged the bullet this time. There will be something else. And this also, by the way, I think this decision can be looked at as the possible foundation for whether a wealth tax would be unconstitutional or not.
Yeah, I mean, that's basically what this sets up. I think this is a wealth tax that the district court has authorized. When we get to the due process clause, part of the decision, the court says even if a tax is retroactive, it does not violate the due process clause if one is supported by legitimate legislative purpose and two is furthered by rational means. Well, first of all, what's the legitimate legislative purpose of taxing someone on their earnings and profits? Okay, it's not legitimate. It's not legitimate, right? We could stop right there. Like, this judge doesn't understand the old words he just wrote. If it's supported by legitimate legislative purpose. Okay, this is Title 26, tax on income. This is not income. You're taxing things that aren't income. Therefore, you're outside the you don't have authorization to friggin' do this.
And it's far worse than that. It's far worse because remember that this applies to the taxation of earnings of non-U.S. corporations, right?
Right.
I mean, it's far, far worse. In fact, at some point in his decision, the judge makes the comment that, where he sort of implies, well, what's the problem here anyway? And what he says is the shareholders, the Moores, have never paid any tax on this. But what he also says is, and this is baffling, the foreign corporation, the Indian corporation, has never paid any U.S. tax. I mean, what that has to do with is completely money. I mean, isn't in fact a presumption that everything in the world should be paying U.S. tax?
Yeah, that's the part I can't figure out.
And I think, this is always the thing too. And I think when I was younger, I was used to be impressed by federal judges. Here's the truth. There are some very brilliant federal judges, but most for the point, you get there for reasons, right? You get there for reasons and you get there because you know how to get appointed. That's why, but it's not because you're a brilliant brain. It's because you know how to get appointed. So, I mean, this is really, when you are, when you're looking at this incredibly massive, and even the second part of what he says, if due process, if it's supported by legitimate legislative purpose, okay, we don't have that, but let's assume that we do. Furthered by a rational means. What's rational here, bud? What is rational about this? Wait. The process is that you don't want certain income that you haven't been able to tax to escape taxation. That seems like you have your butt hurt over your tax doesn't seize everything. Well, it doesn't sound rational. You're just like, well, we're going to get this money no matter what. We don't care. I mean, it's just like they're so greedy for everything.
Well, Anthony, don't you think theft is always rational?
Yeah, right. Always rational. Yeah, so this is what happens when you have federal judges deciding the problem is we have federal judges deciding the scope of the federal government in an area of law that's so complicated. Very few people understand how crazy this is so out of control. And therefore, if you are completely ignorant about the US tax code, you actually probably know more than what this judge wrote. Somebody who really should know better. This is a disgrace. It'll probably be upheld because it's going to go to other judges who are equally disgraceful. It's just a complete shame. And it's, you see the whole mission, the whole mission. No one's administrating this. And I guess, you know what? Maybe I wouldn't be so upset if we actually had an IRS who administered this to say, hey, look, judges, you've been throwing out your laws here. We're the ones who actually have to enforce them. And what you're doing doesn't make our law possible. But rather you have these judges like, okay, here's the law over here. And then the IRS kind of does nothing. And then taxpayers get scared to hell. And then, okay, I'm going to do this. But no one's actually enforcing this. It's like, and that's what maybe we need. And maybe we need all these tax laws enforced 100% on everybody, including all of these federal judges. Let's see how much compliance they are in. I'd love to take a look at their stuff to see what they're not doing right.
Yeah, I would suggest that listeners of this podcast would find it very interesting to read the section, the mandatory repatriate does not violate due process. I mean, if you look at this from a legal point of view, he begins with the principle that as long as there's legitimate purpose and it's rational.
I don't even know where that's from, but
they can do that. Okay, but then they get into the issue of, let's see, as long as, so it says the validity of a retroactive tax depends on whether retroactive is so harsh and oppressive as to transgress the constitutional limitation. So in other words, there are limits on this. But then he looks, now what's fascinating about this is that to decide whether it's harsh or oppressive, I mean, one would think that you would look at that from the point of view of the taxpayer, right? But what he seems to be doing is looking at it from the point of view of the government and saying, oh my God, if they don't do this, then this is something that could escape government taxation. In other words, I mean, would it be rational to say that the judge is reading the due process clause to mean that the purpose of due process is to protect the government from money they can't tax rather than to protect the individual from unjust taxation?
And I think it was a brilliant Freudian slip because that is what the government has been doing. He's just the first person to mistakenly state it, I think. I mean, because this is basically what, the federal judges just want to make sure federal power, whatever it is, we don't care what it is. We just need to maximize federal power. We don't care. We're not going to ask questions about what it is. We just know the answer is, yep, it's a rubber stamp. It's 100% okay. I mean, just look, how many cases taxpayers actually win. Well, I mean, there's reasons why, a lot of cases the government wins because a lot of cases the government doesn't feel great about. They settle before they get that. But overall, if you look at, the federal courts are pretty much rubber stamps. You just got to remember that they're rubber stamps to build the power of the government because their true client is the U.S. government, not the public. Yeah. I think this makes it abundantly clear who they represent. The federal government of the United States in its most massive application, however construed. There is nothing here to stop. With this, there is nothing here to stop a wealth tax. Nothing at all.
Absolutely. What this case means is that there's absolutely no limit to taxation, past, present, future. That's
there
what
you go. There you go. Yep.
Right.
That is what this judge just, this wonderful esteemed judge just said. There's no limits on any taxation right here. And maybe this will be the new seminal case when it works its way up. Yep. Well, remember what Moore said, anything for any purpose at any time is okay. As long as, if the government gets hurt, then, taxpayers got to take it on the chin. Right. Okay. Gotta make sure government gets everything it needs.
That's right. Now,
so gentlemen,
go ahead. Some possible positives here.
Okay.
Would be the following. Number one, I know in Keith's Facebook group, there was some discussion about how this case relates to Monty Silver's Regulatory Flexibility Act lawsuit. The answer is they have nothing to do with each other.
Okay. So Monty's case is still, that's still.
Oh, totally. They have nothing to do with each other at all.
All right.
Monty's case has to do with the regulations made, not the content of the law. This had to do with the content of the law.
Okay.
Second point. It is interesting that this case was brought on behalf of a homeland American who owned a CFC. Now, now it's interesting that, when the judge analyzed the due process issue, again, he didn't really did not at all get into the circumstances of the individual, but it does seem to me that the circumstances of Americans abroad are very different from the circumstances of a homeland American in relation to this issue. So it may be that not is all lost on the due process argument. In other words, it is conceivable to me that the due process analysis could unfold differently if we were dealing with an American citizen abroad who was subject to a separate tax system as well, and for whom the CFC represented a private pension plan, which they often do, rather than a side business, which it did in this particular case for the Moor. So I think that those are some points that perhaps need to be remembered here. Although, in balance, this is an incredibly horrible decision with unbelievable long-term consequences. What the guy is saying is basically there are no limits to taxation, and he's even going so far as to suggest, although he doesn't say it, that the purpose of the due process clause in a tax case is to protect the government's right to tax and not to protect the individual from arbitrary, capricious, rapacious, out-of-control governments, which the U.S. government clearly has become. So I think there's all kinds of grounds for appeal here. I assume that the Moor lawyers will be appealing this, and we'll just have to see.
Right, and I think most federal judges, when they get, when a federal judge gets to federal court, they really might have incredibly limited knowledge of the federal tax code. And this could be a brilliant judge in other areas. I'm telling you, he's a complete rookie when it comes to this. He had no business whatsoever with this opinion. He doesn't know what he's talking about. He's just a very superficial case. And it seems like, a copy and paste of whatever the government's, whatever the government said, kind of went along with. And that's a very traditional move. When you have these judges who don't understand these things, they always will go, okay, the government's got to be right, because why would the government do anything wrong?
Well, the worst thing about this case, Anthony, is on the one hand, the upside down, sideways, and diagonally, the judge says this is absolutely a retroactive tax. I will not buy the government's argument. So it's definitely retroactive. And then he goes on to say, and who gives a damn whether it's retroactive or not?
That was like that fake argument. He was like, he's putting on a show. Hey, look, I'm going to rule in the government's favor, but I'm going to put on a show to make it look like I'm trying not to be even-handed. It's a pretty obvious move. It's like, no, dude, that you're putting up something that doesn't matter. Why don't you talk about the fact that you think it's the government's due process we need to be concerned about, not the taxpayer? Right? I mean, that's, it's kind of like, dude, like I haven't done that. Like I didn't learn that trick in 11th grade, like when I was 11, like, here, emphasize what you're good at. Right? And now kind of go over here. And so he makes a big show. Oh, government, you're so out of control. How dare you make that assertion? By the way, you're totally right. So here we are again. Now I guess, here's a great time to go ahead, Keith.
Yeah. So here's my question. What do we say to Americans? I know John said for Americans overseas with businesses who are in the U.S. tax system, they need to renounce.
Yep.
So obviously they need to pay the transition tax prior to renunciation. Okay. So they're going to lose, they could possibly lose their shirt there. So they're kind of in a difficult situation. So the best people who are in the best situation are the American overseas with a business who have never been in the U.S. tax system. They should just keep on moving forward the way they are.
Yeah, I mean, I'm not going to say that. I don't know if John would say that either. But
no, I'm saying it as a layperson.
Yeah, I would say, this is what I think we said time and time again. Yeah, every case is different. And just because you think you're doom and gloom, don't assume it. And I know that John and I, maybe we all sound a little doom and gloom, but a lot of times, we're more doom and gloom about what can happen. This doesn't happen in every situation, but the fact that this can happen is pretty outrageous. It doesn't often happen. So just talk to someone, get your own opinion, get one or two opinions. You can contact John's firm or mine.
Yeah, you got to get more than one opinion.
Get more than one opinion. And the other thing too, and I think this is really where we should leave off here, because something was set up recently exactly for this. So if you're listening to this and you're getting good and outraged, you can leave your comments on YouTube. That's fantastic, right? But you also can join our new organization, seatnow.org. John's on it, Keith's on it, and this is a great organization to really address these issues in a bipartisan effort. Republicans and Democrats alike are coming together to say this is complete nonsense. This doesn't help anybody who we claim we want to help. So join that now. I do have to hop off. I want to thank you guys so much for this. This is Anthony Parent for John Richardson and Keith Redmond. Thanks so much for watching. And we will probably have some updates on Monty's case going on. And again, join seatnow.org if you are so outraged. Thanks again.